Law at Work is sponsored by Perrett van Niekerk Woodhouse Macholo, leading labour law specialists representing businesses throughout South and Southern Africa, as well as Case Law, the quick, fast and easy labour law search engine.
Hello, I'm Simon Colman and welcome to Law at Work. It is a well-known fact that over 600 cases go through the CCMA's doors each day. Employers are often looking for alternatives, turn to private arbitration. To discuss the issue is Tanya Venter, the CEO of Tokiso Dispute Settlement. Welcome, Tanya.
Hi, thank you, Simon.
Tanya, we're all acutely aware of the issues at the CCMA, and
Yes.
employers are obviously faced with having to discipline their workers and attend to disputes very often.
Yes.
Why would an employer turn to private arbitration rather than the CCMA?
I think it's around flexibility. There's a few reasons why people would go private. The one reason is flexibility. Your terms of reference at the CCMA are defined by the Labour Relations Act.
Right.
If you come to private, you can define your own terms of reference with your workforce or the union that you work with in the workplace. And that gives you a lot more flexibility. The second issue is that we do it in your terms, in that you can determine the venue, the date, where
When
it's
you
heard,
say you
etc.
mean the employer or the employee?
And the employee.
Jointly they would
Yes.
agree to those
Yes.
things.
And that
Okay.
could be an employee represented by a staff association, by a union, by an organisation, or even individual employees. They might agree certain terms in terms of their contract of employment. The other critical thing is that the arbitration is private. And I think
Okay.
it must be emphasised, is the CCMA is a public tribunal,
Yes.
and everything that happens there, including the awards issued, are public in nature. In a private arbitration, the award is private, as are the proceedings.
Okay. In terms of having a private arbitration, why would that be important to an employer? Are you talking about sensitive executive issues,
Yes.
for instance?
And I think that touches on the kind of cases that are coming to us. There's firstly, it's those where there are executive dismissals or executive disciplinary matters coming to
Okay.
us, where there's sensitive matters. And I'll give you an example, like a sexual harassment case, which is extremely sensitive, that perhaps somebody in the workplace doesn't want to oversee, then they may come to private. And the third one is, for example, where there's a shop steward or a employee representative of some sort.
Right.
And it's also quite sensitive in nature, they come to private. And the fourth area is where they want that to design their own private dispute resolution system that suits their particular niche market.
Okay. I think something that could be of interest to our viewers.
Yeah.
Do the parties have to agree to private arbitration before the disputes arise? I'm talking specifically about the transactional HR and
Yes,
IR
yes.
issues, or does it get negotiated, right at the beginning when the person is employed?
It's either or. I mean, essentially, it's preferential that it's agreed up front, either
Yes.
in a contract of employment or a collective agreement with a union or a staff association. However, that doesn't stop a company from approaching the employee or the employee approaching the company as well to say, let's enter into a private agreement here where we go to private arbitration.
Yes.
We will decide when it's heard. For example, if you want your case heard tomorrow, it can be done in private,
Yes.
which means it can be done very quickly, very succinctly, and it can give certainty to the parties immediately,
Okay.
as opposed to going through the full process that it can be many, many months.
A lot of companies and employers that I've spoken to, they're all very keen to go
Yes.
the private arbitration route for obvious reasons.
Yes.
But the difficulty seems to come in convincing the employees that it's also of benefit to them. Could you discuss that? Why would an employee want to go the private arbitration route rather than the CCMA?
I think the critical thing for the employees, if you're an executive, you certainly wouldn't want it out there in the press. You want it to be dealt with quickly, you want certainty immediately,
Yes.
and you want it to be dealt with confidentially. The other thing is that the employees also might have a niche need in
Yes.
terms of the work that they do that requires them to be dealt with in a very particular way, rather than what the CCMA offers. And may I just say that the CCMA offers a very good system, and they
Yes.
work very effectively.
Yes.
However, we offer that flexibility and that alternative option to the CCMA.
Okay, because there does seem to be a perception almost from employees that they've got a greater chance of success if they go through the CCMA's doors.
Yes.
Would you agree with that?
No, I wouldn't.
Okay.
No.
Tanya, how long does it take to conduct a, let's call it a not too complex arbitration, as opposed to, say, how long it would take through the CCMA?
I think it would be probably a bit longer. Essentially, the CCMA has a lot more pressures around budgetary issues, which means that they're much more pressured to finish their cases quickly. In a private arbitration, because it's governed, the parties have agreed the terms of reference,
Yes.
you'll tend to find that the arbitrator will give the process the time that's required. So yes, honestly, it might take a little longer, but it's also to ensure that a thorough process is followed and that the award and the evidence is very well considered so that a fair decision is given. And may I emphasize that as a private organization, Tokiso is as independent as the CCMA in nature.
Okay, so is there a perception, though, from employees, perhaps, that, let me ask it this way,
Yes.
who's actually paying for this private
No.
arbitration? Who funds that?
It varies. It's the parties that would pay for it. We are not subsidized or anything from government or any other organization, and that's quite critical to our independence. Yes. And essentially, the parties come to agreement on who pays. Often it's a 50-50, where there's a union involved. It's like that. Otherwise, the employer will pay, or otherwise, the parties may leave the cost to the arbitrator to decide, saying that the losing party will pay. Yes, absolutely. Or there's some other very flexible options, such as an 80-20 split in favour of the union, so the union pays less.
Okay.
Or otherwise, some companies have come to a kind of a retainer system with us, which means that organizations with their unions, and we always play open cards, and we're always very clear on how it's structured to ensure our independence at all times.
Pre-dismissal arbitration
Yes.
is obviously something that seems to be becoming more popular, especially where there are executives involved in the disputes. But I've heard that this would perhaps then preclude the employee or even the employer from approaching the CCMA afterwards. Is that the case?
Yes. It's like that with all private arbitration.
Okay.
Is that you're essentially contracting out of the CCMA. And that's one of the benefits, is that you don't have all these forums to go to after the matter is concluded. The Labour Court has an inherent jurisdiction to review all cases. And that's an inherent jurisdiction. You can't contract out of that. As our CCMA awards are subject to review, so are Tokiso private awards. Coming to the pre-dismissal arbitration concept, unfortunately, it's not as popular as we would like, and I think that's because people are not aware of the option. It's becoming slightly more popular, but really it's not grown at the pace that one would anticipate the system. And I think it's because people don't understand what it is.
What are the benefits?
Okay, basically, let me start with what is a pre-dismissal arbitration.
Okay.
I prefer the term disciplinary arbitration or a incapacity arbitration, where basically somebody can bring the arbitration, a final and binding arbitration, at a disciplinary inquiry stage, so that the decision is final and binding at a disciplinary stage, which is only subject to a Labour Court review. And that makes sure that it's quickly and effectively dealt with by an independent person who can make a decision right there and then. And the benefits is how quickly it happens. Is the Act, the amendments of the Labour Relations Act in 2002 made provision for this option, and Tokiso gets the private referrals on this basis, and we're very effectively dealing with disputes on this basis, and very quickly. And like you said, executives, it's particularly beneficial for an executive where it's extremely likely that you're going to get an outside person to chair the disciplinary anyway.
And get it moving a lot faster.
Very much so. So why not just bring the arbitration up front, hear it there and then, so that all parties concerned can move on quickly. Excellent. And my sense, especially of these disputes, is that they are very costly to companies and to employees in terms of both reputation and money.
Okay. Tanya, thank you very much for joining us in the studio.
Thank you,
And
Simon.
to you at home, goodbye.
Thank you.
Law at Work is sponsored by Perrett van Niekerk Woodhouse Macholo, leading labour law specialists representing businesses throughout South and Southern Africa, as well as Case Law, the quick, fast and easy labour law search engine.